Hello everybody, this is Urvi Gupta. I am an intern at ubAdvocate and today I would be dealing about development of concept of passive euthanasia in our country. Before starting, I would like to apologize for any background noise because some construction is going on in my house. Moving further, before dealing into the topic, I would like to mention and discuss some important provisions, namely Article 21 of Constitution of India, Section 306 and 309 of the Indian Penal Code. The whole controversy and the whole timeline of passive euthanasia revolves around these provisions. So it is very important for all of us to know what they entail. Article 21 of Constitution of India talks about right to life and personal liberty of all human beings. Judiciary has played a significant role over the years since the commencement of the Constitution to interpret it in the widest possible manner. So many rights have been enumerated in Article 21. Section 306 and Section 309 of Indian Penal Code talks about abetment and attempt to suicide. So now I will be dealing with the topic with some of the major case laws. So we will start by the case P. Raminathan versus Union of India. In this case, the court relied on the case of R.C. Cooper versus Union of India. Moving forward, I would like to tell you that petitioners in this case approached the court with a very peculiar argument. They were of the opinion that since the right to equality included right to be treated unequally, because right to equality contains the provision for positive discrimination in Article 15 and the principle that likes should be treated likely and unlike should be treated unlikely. So they were of the opinion that right to equality included right to be treated unequally and right to freedom of speech included in its ambit the right to keep silence. So Article 21, that is right to life, must include right to die as well. On this ground, the petitioners claim that Section 309, which criminalizes suicide, that is attempt to suicide, was unconstitutional. As I told earlier, the court placed reliance on R.C. Cooper versus Union of India and held that since the fundamental rights are not tightly bound containers, the argument is valid and Section 309 is unconstitutional. 2 years later, a separate case of Gyan Kaur versus State of Punjab was filed. In this case, the court was to test the constitutionality of Section 306 of the IPC, which criminalized abetment of suicide. Petitions contended that since suicide was no longer illegal, the abetment of a legal action cannot be criminalized. Court observed that the previous decision in P. Ratina versus Union of India was flawed and it must be overruled. Although the right of life does not include right to die, right to live with dignity should include the right to die with dignity, and since an unnatural death can never be construed as death with dignity. So the court held that suicide is not a natural form of death and it must be criminalized. It was on the principle that when God gave us life, it is only God who can take it away. Hence, they overruled P. Ratina and reinstated the validity of Section 309 and 306. After around a span of 15 years, the case of Aruna Schonbag versus Union of India was filed in 2011. In this case, the court distinguished in detail about active and passive euthanasia and declared that passive euthanasia was not illegal, it was legal. The court considered passive euthanasia a natural form of death and laid down some guidelines. In a nutshell, it concluded that Parliament is competent to form any legislation on passive euthanasia. That comes the case of Common Cause versus Union of India. In this case, the 5-bench judge disagreed with the Aruna Schonbach case and said that the bench in that case was flawed in holding that passive euthanasia would be legal only after a competent legislation. Hence, they discuss in detail the living will, that is a dying declaration, that is declaration of a person when he is in the sound state of mind that he is not willing to be put on life support in case if he is in a vegetative state. Hence, it can be said that passive euthanasia is now legal in this country. Passive euthanasia means non-use of a life support system in case someone is in a vegetative state, while active euthanasia means administering a drug that would hasten the death. So active euthanasia is not legal, while passive euthanasia is legal. I hope you could